something that is a bit, at times it gets a bit institutional. So I got inspired a little bit by reading, I was at a Law and Society conference in the United States, as one does, and then on a long plane flight back, I started writing what turned into the abstract for this paper. I had read Ed Rubin's piece on future of legal education there, which some of you know well. That's a response to a particular dynamic happening there about a relative fall in law student numbers, are law schools failing? He says, this is Ed Rubin, no, they're not. You don't have to turn away from faculty research. You don't have to dumb down effectively into two-year programs. You can, you do have to recognize what's going on in the social context. That means the shifts in capitalism, shifts in the economy, also demand for social justice. What does that do? Law schools need to transform educational programs to reflect more of what's happening in the professional world, but also the interdisciplinary nature of modern legal, well, he's saying practice, but I think it's also the thought in the education. Here, Fabio Desai Silva is doing some preliminary research about legal education within the BRICS countries, Brazil, Russia, India, etc. His conclusion, looking at them, is that law schools have survived in the past few decades, thinking of some of the countries that he's been looking at, but that at the moment, there's a sense that the law schools aren't producing lawyers able to meet globalized legal profession, and there's concern now about quality and accreditation of the law graduates in these BRICS countries. Now, we had a discussion in this conference yesterday about the degree to which South Africa was a late adopter of law and society. I think actually one can parallel a little bit and say that maybe some nuances, maybe some more research, but you could argue that South Africa fits this comparative BRICS trajectory, but as a late adopter, a relatively late globalizer in that sense. Only in the 90s to big law firms here, Joel was talking about the corporate firms. I actually wish that they had slightly more influence within the law schools in a certain sense. Not influence, but in the sense of like funding the schools. At least I mean that part. But really, they did only emerge in the corporate part. I mean, the profession was always there, but the corporate part really only gets big in the 90s. And the critical nature of the situation in South Africa, I think, is a domestically driven discourse rather than a global one. The crisis here is a domestic one, and I don't think South Africa has got the same degree of proliferating lawyers and falling social prestige as seeing in other BRICS. I always have a vision of, this is really unfair because I've never been there, Brazil, but I just have a sense of like lots of law graduates in Brazil and none of them getting jobs, and et cetera. And people seem to be concerned about that. Okay, so a crisis, a professional crisis. Joel has told you about the profession saying our graduates can't write, et cetera. I think there's also, this abstract was written before even the first, well, in the middle of 2015, so it was talking about a sort of incipient financial crisis that turned into fees must fall, which is a broader thing as well. But there is a financial crisis from the institutional point of view as well as the students paying fees. I think there are, okay, so on the professional side, the profession has been complaining about the graduates. That changed. The profession now partners with the deans. They stopped complaining and they started working with the deans. This may be good, this may be bad, right? But the critique remains. The profession has no direct power over the schools. It's got accreditation power, it's got soft power, influence, etc. But whereas in the US, the profession has got direct power over the schools, here the law schools are within the university. And that has to be recognized. The profession also does participate significantly in legal professional training. They are legal education providers. They kind of don't think it, we don't think it, but they are. They do the in-house training and they do practical legal training. And I think one part of my talk is to actually emphasize that we need to take that on board and work with it. In terms of the financial crisis, law schools, cash cow within universities. Not true in every university, but by and large, cash cow. There's an insignificant degree of financial autonomy for ring fencing or reinvestment in the law school budget. I think it may be that UCT and UP are different to that, but we have law school bureaucrats who, sorry, Lisa, not a bureaucrat, but at time managers, well, you fight budgetary battles. That's the only part that I'm going to there, and those have to do. A third crisis, fees must fall, that's broader. I think when I write this up into a good paper, I think that needs to be maybe a third crisis that's really talked about there. Did this crisis get resolved in 2012, 2013? There was a summit, there was a sense that it had been resolved. People were talking about the way to do this was to extend the number of years in the law degree from 4 to 5. I think it wasn't clear if that was a move back to an earlier pre-1977 notion of the postgraduate degree, or whether it was a structural change of increasing the number of years in an undergraduate degree in both regular undergraduate education and professionalized professionalized education. I'm on the side of the move all of the undergraduate education up by 1. I think that would be moving more towards the humanities side, but I think definitely some persons are effectively harking back to a imagined, pure, lovely time when there was a postgraduate law degree and the graduates, who were mostly white, of course, could write. The move from the postgraduate degree to the undergraduate degree in South Africa in 1977, the promise and the rationale for that was that the new 4-year LLB would be open to black as well as to white students, making the critical ticket for entry into the profession widely available. The student body has changed. There's actually been interesting changes within the rest of the university because of this change. A colleague of mine at Weiser has pointed out that there's actually less student throughput and less support for the staff in the humanities because of the changes in the legal education sector. And it's another point that we, like African language, the African languages departments shut down in some places. And that is because of the shift in the legal education. Well, it's not because of, but there was a interaction effect and a contributing effect there. And so we need to be thinking about the education within a broader context than just the legal education. What's been more slow to change than the student body is obviously the staff and the curriculum. I think there are different reasons for those two different aspects, staff and curriculum. Very little attention to transformation of the faculty in terms of numbers and analysis. Tsepo Madligozi is an exception there. He was out early on this point. But again, law schools are South Africa are very different, and there's no kind of formal national legal market. It's kind of a set of informal practices in each one of these 21 faculties. All of us here who teach within would have peculiar stories of how actually the positions are, in some cases actually, it's fair to say, handed out. The curriculum, I won't say more about that there, but I think it is fair to say, well, doctrinally focused, not much practical appreciation. There are different roles that are being played by legal professionals that aren't always recognized, little use of options for external learning. There is, here I think I'm pointing at what levers do the law schools actually have. They've got largely self-regulation power over the content of the curriculum, and actually, to a large extent, the number of credits, 5 minutes, thanks, required for graduation. What that means is that with the credits, they actually can kind of structure the degree programs in much their own way. And if you look at the different 21 schools, you will see UCT is different from Rhodes, is different from Zululand, is different from UP, is different from, where actually in each one of these, and my colleague Hlonipa Mokoena Weiser is also intensely aware of how the crisis at each one of the universities is actually different, because you've got different percentages of, for instance, students on NSFAS funding, different missing middles, different effectively degree structures. So we need to be careful about that. We particularly need to be careful about that when we have a panel that's got UP and WITS and UCT. And we're all in the top, bit of the hierarchy. And the hierarchy of the law schools and the universities has not changed. Although it's fair to say UP's done much better over the last 20 years. Yeah, and possibly WITS less better. Coinciding with my time there, but anyway. Okay, there's some status numbers here. There are more graduates now than 20 years ago, right? 4,500 versus 2,700. They are more representative. Now the black law graduates are outnumbering white by 2 to 1. I don't have the earlier figures on that one, but I'd sort of guess they were about reversed. May not be right there, but I don't think the employment story is so bad, actually. There's some studies that says that only 18% of those completing a degree attrit and do not gain admission as an attorney. So for those who want to get into the profession and who do stick around long enough and are willing to go far enough down the hierarchy into solo firms as opposed to corporate firms, I think there is actually a road in there. But where there is precarity is in the student body, where NSFAS funding, et cetera. So we need more data to be sure about that. And I think it's also true what Joel said, that we need to recognize the degree to which our graduates are not going into the profession, but actually going elsewhere in the economy. So that's my last slide, which has 1 minute. And I wanted to get there with 5 minutes left, but maybe we can come back to that in question time. But these are all ways forward that I would call structural. And I think to some extent they're all happening, going to happen, etc. But it is a question of in what packages, in what priorities, etc. But I've talked a little bit about the first one, extension of the years of the undergraduate degree. Law is language. I think we need to talk about that more. Language is an extremely important cultural, not only signifier, but carrier, etc. And I've been struck by, we had historical debates in the legal profession about getting rid of Latin. Maybe there need to be a new set of debates about bringing in, quote, Zulu. Undergraduate studies, one thing to do with the new structure of the degree since '97 is to expand undergraduate social legal studies. This will lead right into, might lead into our next paper, but about doing more interdisciplinary work in the undergraduate degree. So I've said that the profession is actually doing practical training. So the big corporates are doing in-house training. You could get them together to do a law firm school or something. That might be worth thinking about. It might be supping with the devil or whatever from certain points of view, but law clinics as graduate civil justice centers, one of the interesting unintended consequences of constitutionalization is, of course, that with greater legal aid, an increasing proportion of the available national budget for legal aid goes to men rather than to women, because men are disproportionately criminal accused. That's where the funding is going. There's less funding for actual civil legal aid, and there's an important thing there about where law clinics could be. An increase in private legal education we'll talk about. I think it's happening. I don't think it's the worst thing in the world.